Congress shall make no law abridging the freedom of speech. Ratified in 1791, the text of the First Amendment appears to protect all speech, without exception. But the Bill of Rights was ratified against a background of law which already prohibited some speech, and the Supreme Court has since approved other speech prohibitions. These categories of speech which the Supreme Court has ruled are not protected by the First Amendment include fighting words, words which by their very utterance inflict injury or tend to incite an immediate breach of the peace; defamation, false statements which tend to injure a person in his reputation or bring him into public contempt; incitement, speech which is directed to inciting or producing imminent lawless action and is likely to incite or produce such action; obscenity, speech which depicts or describes sexual conduct in a way that offends the community. The Supreme Court has ruled that a law banning speech which falls into one of these categories does not violate the First Amendment. There are other speech categories which aren't wholly unprotected, but which are viewed as low value. Government may not entirely prohibit low-value speech, but it can restrict it significantly. Low-value speech includes non-obscene pornography, indecent language, and commercial speech. The last of these three categories requires some explanation. Commercial speech is essentially about buying and selling. The Supreme Court has defined it as speech which proposes a commercial transaction. Although this definition is narrow, it covers a large percentage of speech. Just consider the percentage of the Internet that proposes commercial transactions, or the percentage of your daily mail that is coupons or advertisements. Also consider how odd it is that the Supreme Court has categorized commercial speech as lower value, when the economic well-being of most Americans depends upon the effective use of commercial speech. Speech that is not categorized as unprotected or lower value is considered fully protected speech. But even fully protected speech is not safe from government restriction. When a law or policy abridges fully protected speech, the first order of business is to determine the reason for the restriction. If a law or policy restricts speech only because it causes problems due to the time, place, or manner of its delivery, the Supreme Court is more lenient. A law which prohibits scattering paper on public streets, for example, is not invalidated by the Constitution, even though it does block one manner of speech. Similarly, a noise ordinance that prevents sound trucks from blaring announcements in the middle of the night does not violate the First Amendment. The key feature of each of these laws is that they do not discriminate on the basis of the content of the speech. Any speech in the prohibited time, place, or manner is banned, regardless of its content. This does not mean that these laws always survive constitutional challenge, but the Supreme Court is more lenient in its review. When government restricts speech because of its content, however, the Supreme Court examines the law with care. This careful examination of speech-restricting laws is called strict scrutiny, and strict scrutiny makes sense in these circumstances because when the government is banning speech on the basis of its content, there is the potential for serious abuse. A law is treated as a content-based restriction if it bans speech because of the viewpoint expressed, the subject matter, or the speaker's identity. The Supreme Court excuses its acquiescence to these content-based speech restrictions as the best resolution of unavoidable conflict between important opposing values. On one side of the conflict are the values animating the First Amendment, preserving liberty, protecting the political process, furthering the search for truth, permitting personal fulfillment, and so on. On the other side of the conflict are arrayed the government's interests, maintaining order, preventing violence between citizens, protecting community morals, discouraging crime, and so on. The Supreme Court employs a number of different tests to decide whether the First Amendment values or the government's interests will win out in a particular case. But all of these tests are designed to answer two essential questions. First, is the government's reason to restrict speech more important than First Amendment values? The Supreme Court uses the term compelling governmental interest to describe this kind of important reason. And second, is the law or policy that the government is using to restrict speech appropriately written and implemented to accomplish its purpose? The Supreme Court names this kind of appropriate law or policy narrowly tailored. The first of these two questions is a kind of balancing test. The Supreme Court balances the importance of First Amendment values against the importance of the government's reason for blocking the speech. If the court thinks the First Amendment values are more important than the interest served by the government regulation, then the regulation is struck down as unconstitutional. Even if the Supreme Court decides that the government's interest in restricting speech is compelling enough to outweigh First Amendment values, the court may still rule the restriction unconstitutional, depending on the answer to the second question. The second question examines the appropriateness of the speech-restricting law or policy. One reason why laws fail this part of the Supreme Court's test is overbreadth. A law will fail due to overbreadth if it restricts more speech than can be justified by the government's compelling interest. By way of illustration, suppose that this green square represents all speech. Now suppose that this black square represents the speech that the government wishes to ban and is justified in banning. Finally, suppose that this red square represents the speech that the law actually bans. If a law bans more speech than necessary to achieve the government's purposes, then that law is overbroad. An overbroad law is unconstitutional because it prohibits some speech that the government has no legitimate reason to prohibit. Now, with this brief overview of First Amendment law, let's turn to the Supreme Court's recent decision about political speech in Citizens United versus the Federal Election Commission. Protecting political speech has always been one of the core purposes of the First Amendment, yet Congress has seen fit from time to pass laws abridging speech relating to political campaigns. The fear was that wealthy individuals and organizations might purchase political favors by donating large amounts of money to lawmakers' campaign funds, and this fear is not an imaginary one. A brief look at the U.S. Income Tax Code is enough to prove that. So in the early 1900s, Congress began to pass laws to regulate campaign finance. In 1971, Congress consolidated these laws under the Federal Election Campaign Act, and of course, Congress hates to pass up an opportunity to add a new bureaucratic agency, so in 1974, Congress created the Federal Election Commission to administer and enforce these laws. Then in 2002, Congress added additional restrictions in the Bipartisan Campaign Reform Act. Citizens United versus Federal Election Commission was a lawsuit about provisions in these campaign finance laws which prohibited independent expenditures and electioneering communications by corporations and unions. An independent expenditure is an expenditure expressly advocating the election or defeat of a clearly defined candidate and that is not made in concert or cooperation with, or at the request or suggestion of, such candidate, the candidate's authorized political committee, or their agents, or a political party committee or its agents. An electioneering communication is any broadcast, cable, or satellite communication that refers to a clearly identified candidate for federal office and is made within 30 days of a primary or 60 days of a general election. Incidentally, speech which would otherwise be banned as an electioneering communication is permitted if it appears in a news story, commentary, or editorial distributed through the facilities of any broadcasting station. The upshot of this rule was that news corporations like Fox News and CNN could use their corporate wealth to talk endlessly about politics and candidates, but other corporations could not. This was the legal environment in which Citizens United brought its lawsuit. Citizens United is a non-profit corporation which was created to influence politics. Within 30 days of the 2008 primary elections, it intended to offer a derogatory movie about then-presidential candidate Hillary Clinton through video on demand. The movie, entitled Hillary the Movie, clearly fell within the category of electioneering communications, and may have fallen within the category of independent expenditures. As a corporation, if Citizens United had released the movie through video on demand as planned, it would have been fined and criminally prosecuted. So Citizens United sued to obtain a court ruling that would permit it to broadcast the movie without penalty. Enter the First Amendment. Recall that the first step in First Amendment analysis is to determine whether the banned speech is unprotected, low value, or fully protected speech. Don't make the mistake of assuming that the movie is lower value commercial speech merely because Citizens United, a corporation, created it. Recall that the Supreme Court defines commercial speech as speech which proposes a commercial transaction. Hillary the Movie is not proposing a commercial transaction. It is a clear example of political speech, so it fits into the category of speech that is fully protected by the First Amendment. The next step in First Amendment analysis is to determine whether the law restricts speech because of its content or only because of the time, place, or manner of its delivery. The federal campaign finance laws challenged in the Citizens United lawsuit restricted political speech by corporations because of their identity as corporations. Recall that banning speech on the basis of the speaker's identity is a form of content-based speech restriction, and content-based speech restrictions are the worst kind. content-based speech restrictions are subject to strict scrutiny and will only be upheld as constitutional if the government has a compelling interest in restricting the speech and the law or policy is narrowly tailored to promote that interest. The government offered 3 justifications as compelling interests for its prohibition against corporations and unions engaging in independent political speech. 1. To prevent corruption or the appearance of corruption, the anti-corruption rationale. 2. To prevent the distortion of the political process resulting from the aggregation of wealth that can be achieved through the corporate form, the anti-distortion rationale. 3. To protect shareholders from having their money spent on political speech that they don't agree with, the shareholder protection rationale.